In this segment, we're going to begin a discussion of the judiciary in the United States. The judiciary includes a set of federal courts topped by the U.S. Supreme Court and all of the state courts, headed in almost every case by a court of last resort, which in most states is also called a Supreme Court. This discussion is wide-ranging and will cover a wide variety of topics, so we need to go through it step by step, and I'm going to begin that process now. The first part of the historical record is that the state courts existed first. In the 13 colonies that had rebelled against Great Britain, declared their independence, become independent states, combined together in a confederation known as the Articles of Confederation, they had a long history. Some of it was not very distinguished because the judges had all been appointed by the Crown, and these people were gone. But the fact that we had all of the separate court systems in the 13 states was of critical importance. These people had formed part of the polity of the 13 states. To eliminate them entirely would be impossible. So what the founders did was to lay on top of it another court system, the federal court system, which could decide disputes between the states. One of the critical limits of the Articles of Confederation was the lack of a national court system. If there were a dispute between a farmer in Connecticut and someone selling retail produce in New York, no way to resolve it. The Connecticut farmer wants the case decided in Connecticut. The New York retailer wants the case decided in New York. Both are favor their own home state courts, and nothing gets decided. So the Supreme Court, in Article 3 of the Constitution, established a Supreme Court. And that's all they did. It said it would be the Supreme Court deciding the law of the land. But they didn't spell out any details. Instead, they left it to Congress and the President to decide what additional courts needed to be made and to create all kinds of enabling legislation under the Constitution. That's where the federal court system came in. The reason we have a dual court system of state and federal courts today is because that's the way the history of the country went. That's the way in which the Constitution was written. Now, notwithstanding what I've just said there, a certain kind of legal doctrine was already present in the country. We had inherited our court system from Great Britain, and a big part of the court system was the common law. However, the American Revolution had strains in it that challenged the common law, so it was not immediately and universally accepted. But parts of the common law simply could not be ignored. They were a part of the legal system, and all of the laws, including the laws of those 13 states, already recognized parts of it. We had then an evolving legal system from the start. And one of the principles that existed, that shows up in all of the state courts and shows up in the federal courts, is the notion that a case could be decided wrongly on the initial level. In the first case, in the court of original jurisdiction, which is often called the district court, even in the states they're called district courts, the district court could make a mistake. The district court could make a mistake in terms of deciding what the law was. So there was a right to an appeal, one appeal to a court of appeal. And because the court of appeals might also make a mistake, there was often the right of a second appeal to a court of last resort. That's what we have. Federal district courts, cases are heard there. The loser in that case can appeal to the Circuit Court of Appeals, the next court up, and that appeal will be heard. However, when you go to the next step above that, the step where you go from the Circuit Court of Appeals to the Supreme Court, whether the case will be heard or not is discretionary with the Supreme Court. It has to be that way. There's no other court you can appeal to higher than the Supreme Court, so if the Supreme Court simply doesn't want to hear the case, they simply won't hear the case. And if you tried to force them by law to do it, they would simply give you perfunctory, non-useful decisions. So the discretion of the Supreme Court in the federal system and the discretion of the Supreme Courts in all of the states that I'm aware of are the that the Supreme Court can decide not to hear a case if they don't want to. In technical terms, hearing the case by the Supreme Court requires getting a writ of certiorari. Indeed, a writ of certiorari, sometimes called a writ of cert or simply cert for short, is an order from a higher level court to a lower level court to prepare the documents of a trial to send them on to a court of appeal. Without a record of the trial, the Court of Appeal can't hear the case, so you have to get cert in order to go anywhere. If you're going from a district court to the Court of Appeals, you're going to get cert. Eventually, you will get an order from the higher court to the lower court asking them to prepare the record and send it up. In the case of Supreme Courts, though, cert can be denied. Indeed, in the case of the U.S. Supreme Court, where they get thousands and thousands of cases and couldn't begin to hear them all, they will get maybe 4,000 cases, and they'll end up hearing, in the course of a term, maybe 70 cases. Those are the only cases for which cert is granted, or a writ of certiorari is granted. Now that's the structure of the courts, and it carries through all of the states and the federal system. So that part of what we inherited from Great Britain is unassailable. We have always had this notion that everybody has a right to one appeal and a discretionary second possibility of appealing it to a higher court. That's the structure of the courts all across the country. Now, in the course of this, I've made reference to something that I haven't yet defined. I've talked about original jurisdiction, and I've talked about appellate jurisdiction. So it's time to look at it. Original jurisdiction, as its name implies, is where the case starts. It will start in a district court, and that district court will do the following. It will hear facts. It will try to establish facts. What's a fact? Well, a fact isn't just an ordinary fact. It's a legal fact. It's a legal fact like who's telling the truth, who is guilty of a crime, who is guilty of an act for which a civil penalty sets in, who has committed a tort, who has violated a contract. These are all legal facts that will be established in a district court or a court of original jurisdiction. The court of original jurisdiction will also establish a record. It is now routine to have stenographers take a record of everything that is said in a trial to establish a written record of what happened in the course of that case. And finally, a court of original jurisdiction, in its effort to seek to establish facts, will be the court that uses juries. If it doesn't have a jury, the judge will be acting as the trier of fact. But notice that the phrase trier of fact applied to juries and applied to judges is the means to establish the facts. It is intended that the facts be established in this case. It is intended that all facts will have been decided by the district court and no new facts will be established by an appellate court. That means that the appellate court is not overturning a jury directly. Appellate courts, it is said, try questions of law. Now, a part of the law that they will be deciding are the laws governing courtroom procedure. So if a judge made a mistake by allowing the wrong kind of evidence to go to a jury, the jury might have been misled, and the jury's verdict might be invalid. But it won't be invalid because the jury was wrong. It'll be invalid because the judge made a mistake. In this country, another of the legal principles is that if you're going to appeal the case, you have to appeal it on the law, not on the facts. This becomes important when you realize that appellate courts don't have juries. They have no method by which they can establish facts. An appellate court that decides against a district court is going to be an appellate court that's going to decide to send the case back down for rehearing or retrial. The appellate courts don't have juries, and the next step up, the Supreme Court also doesn't have a jury. There are no juries in those cases. Appellate jurisdiction belongs to the appellate courts. There is an exception. In the U.S. Constitution, a narrow range of cases exist in which the Supreme Court could hear a case by original jurisdiction. The case could originally be filed with them. In that case, the Supreme Court would be acting not just as a determiner of the law, but they would also be deciding a case in which they were the triers of fact. But the number of original jurisdiction cases are infinitesimally small compared to all of the appellate court cases that exist. There is a kind of notion in America that all cases can be appealed to the Supreme Court, and that's not true. You may have heard as a child the notion that if you have a problem, you go to court, but you could appeal that case all the way to the Supreme Court. Yes, you could in a few cases in which the jurisdiction was appropriate, but in other cases you'd have no way to get there. What does it take to have a case that can be heard by the Supreme Court? Putting aside certain technical cases that have original jurisdiction, there are two basic ways that a case can be heard in federal court. One is the challenge of the constitutionality of a law. You challenge a state law in federal court, you challenge a federal law in federal court. Those cases can be heard directly by the district court, and the process of going to the Supreme Court can begin. The second kind of case is a case of diversity of citizenship. That's a technical phrase for saying that you've got two parties that live in different states. Earlier, and I was talking about the situation of a Connecticut farmer and someone selling produce in New York. They would clearly have diversity of citizenship. They live in different states, and just as under the Articles of Confederation, either party would have liked to have the case heard in their own home state court. Because they live in different jurisdictions, jurisdiction will be in a federal court. The issue at all points is the feeling that people who live in a certain state would favor having the case heard in their own state courts. If they're heard in their own state courts, there's all kinds of possibilities for them to get advantages as a result of being the home state person. Move to a federal court, even though the federal court will be located in the state, even though the federal judge is extremely likely to come from that state, even though the jurors in those cases will come from the state, the fact that it's one level up enlarges everything. It enlarges the point of view of the judges, it enlarges the point of view of those who bring in the case, and it increases the jury pool by a much larger percentage of the total area in which a jury would normally be taken. For this reason, federal cases involving people from different states are preferred over trying to resolve the matter in state courts, at least as a general rule. This is the basic outline of the legal system that we have. I'll be taking up some additional questions in the next segment.